What else is new and entertaining in the law in 2013? My favorite commission this side of the Third Reich's Auswärtiges Amt, the Commission on Judicial Conduct, removed a town justice from office and extracted a promise from him never to be a judge in New York for the rest of eternity. His offense, among other things, confronting a 15-year-old kid he suspected of stealing something from him, yelling profanities at him, taking his bicycle, and returning it to the parents. Just how this reflects on a judge's ability is beyond me, let alone what could possibly be a violation of any rule. Well, according to the boys at the commission, this violates 22 NYCRR 100.2a and 100.4a, in that he, quote, failed to act in a manner that promotes public confidence in the integrity and impartiality of the judiciary, and he, quote, failed to conduct his extrajudicial activities so that they did not detract from the dignity of judicial office. Really? This interaction detracted from the dignity of judicial office? Not to my eyes, but I guess a judge must open his life to all aspects of scrutiny if he seeks judicial office in New York, as the commission has its own unique view of dignity. If this kind of private interaction justifies removal from office, I dare say I wouldn't last more than a week on the job. Just ask my neighbors. Of course, that is just the tip of the iceberg in the court system news of the weird this month. Remember, the chief judge passed a rule requiring us to keep track of the time we spend on voluntary, unpaid, pro bono services to the poor and underserved clients. Of course, this must be read with the Chief Judge's Rule 6.1, requiring us to, quote, aspire to provide at least 50 hours of pro bono legal services each year to poor persons. Well, this rankled a few organizations, as the interpretation of the services to the poor and underserved is a bit too vague. So on June 7, 2013, the lead counsel to the Unified Court System clarified that this includes a host of other, even more ill-defined tasks, such as, quote, activities related to improving the administration of justice by simplifying the legal process for or increasing the availability and quality of legal services to poor persons. Are you kidding me? This is laughable, as the Unified Court System and its bureaucracy has been the number one enemy of simplifying the legal process for poor and rich alike. Just ask anyone who has recently filled out the silly, useless, matrimonial request for judicial intervention addendum, otherwise known as UCS 840M. Or try the one of the 30 forms of the uncontested divorce packet, which ludicrously states this divorce packet may not be for you, or anyone else. Thank you very much. By the way, the nifty uncontested divorce packet form of the automatic orders does not have the updated automatic orders of the Office of Court Administration. It seems like the OCA bean counters cannot even keep up with their own silliness. As pointed out by Bruce Wagner in his column in May, the orders, which are not really orders anyway, were amended in January to include a statement that the failure to obey these orders may be deemed a contempt of court. Putting aside that the divorce packet alters this language, maybe the failure to obey will be contempt and maybe it won't. The last I looked, an order is something signed by a judge, not attached to a summons by a lawyer. Saying it is won't make it so, but OCA thinks that an order of the chief judge to attach some notice to a summons constitutes an order punishable by contempt. To me, it doesn't. Imagine the jailhouse conversation. What are you in here for? Well, the chief judge ordered that the summons of my divorce contain a notice that I not change the beneficiary of my life insurance, and when I did, I was thrown in the slammer. That and donating my shirts to Goodwill. What are you in here for? Finally, did you see that Taiwan's Minister of Culture, Lung Ying Tai, said she is embarrassed by Criminal Code Article 239, which provides that married spouses who commit adultery be imprisoned for up to 1 year. One commentator says that this archaic law puts Taiwan on an inglorious list with conservative South Korea and the Islamic countries. Add New York State to that inglorious list, as last I looked, adultery was still a Class B misdemeanor under the penal law. Of course, that could get you 90 days in the slammer with the guy who disobeyed those pesky unsigned automatic orders.